thank you very much for inviting me. I think this is a very happy occasion and a very important occasion, as you indicated, a symbolic occasion. I'm very grateful to Ian and Jean for inviting me. I'm very grateful to the university and the law faculty for inviting me. I have some connection with the law faculty since my father did his law degree at this law faculty, and he won a prize for international law for writing about the conversion of a merchantman into a man of war. I'm not sure why he was doing that. He never did any international law afterwards. And bought my mother's engagement ring with it, so it must have been quite good, or a rather cheap engagement. In any event, it's great to be here. I think that what I'm going to do is speak quite briefly so we can have questions and answers. And I talk about three things. Firstly, the Melland Schill lecture series. Then a bit about the general question of the importance of writings for international law. And lastly, if there's time, a little bit about the International Law Commission and what it is doing about the importance of writings for international law. So, first in the series, it seems to me that there's a great merit in having a published lecture series, because it tends to get people to effectively write books who might not otherwise write a book. You invite them to come and give a lecture, or a few lectures, and that's relatively easy, and then you say to them, oh, and we'd like to publish them, so could you just tidy them up a bit? And you get books by people who might not otherwise have thought of writing a book. So I think it's very good to have lectures that stimulate people to write good books. That's one reason why I'm very pleased that you've restarted the lecture series. Though I think they're going to be individual lectures, and publication will be online rather than always as articles or books if they can be expanded. But I would hope some of them would lead to a book. As you all know, I think there are 16 books in the lecture series that are online. There are 17 volumes, but 16 books, because Ian Sinclair is there twice, first edition and second edition. Ian Sinclair's book on the law of treaties is one that I look at very frequently and use in court as well. And I had to borrow the Foreign Office's copy and get my chambers to make a photocopy of it because it wasn't available otherwise. So it's a good example of how these books are really still being used. I have to say that I have a lot of affection for these Melland Schill lectures books, because they came out when I was studying international law in the 60s, the late 60s, and they were really some of the most important writings in international law were those that came out in this series. For example, there's Clive Parry's, Professor Parry's masterly lectures on the sources of international law, which is a volume that I still look at frequently, and I regard it as the Bible on the subject. I know there are more recent books on it, and books that are no doubt equally good, but I regard Clive Parry's book as the best, partly because he taught me, so I tend to agree with what's in his book, and find it comforting to read it. Then we have Professor Jennings's book on the acquisition of territory. That's another book that, whenever you have a problem of territorial sovereignty, the first place to look is in Jennings's book. It really is a well-structured book that sets out the law. Even though it was written now some 50 years ago, it's still an extremely valuable starting point. Some of the others in the series are perhaps a little more dated, but then, as we all know, history is very important in international law. You do need to know what the legal position was in the past. And an example of a somewhat dated book is that by Derek Bowett, a very great international lawyer who spent a lot of time, I think, at this university. His book encapsulates the law of the sea in the very early 1960s, at a critical moment when, between the first and second conference and the third conference, the law was was reaching a point of crisis, and he foreshadows in that book the various tensions that exist in the law. And I reread it. It's very short, it's about 60 pages. I reread it the other day and found it very illuminating. Another book that interests me a lot is by Francis Verlat. In fact, 3 of the books in the series, 3 of the lecture series were by Foreign Office lawyers whom I knew: Francis Verlat, Joyce Gutteridge, and Ian Sinclair. Francis Verlat's book is about the practitioner, international law and the practitioner. And it really shows you, when you read that, how much has changed in international law since he wrote that 50 years ago, but also how much is the same. He said that he was trying to explain some points of contact between international law and the private practitioner, the practitioner in private practice. And if you read the book, you get the feeling that practitioners really had very little to do with international law. This was only something that the Grand Foreign Office did, and we really need to talk to practitioners about it. And the book covers just 2 or 3 things. There's a chapter on the relationship between international law and municipal law. Well, that's of great interest still. There's 2 chapters on international claims, which haven't really come up big time for the UK anyway. They have for the US, Iran, and for against Iraq, but the kind of claims that Verlat deals with in 2 of the 5 chapters just don't really come up again. They've abolished the Foreign Compensation Commission, I think, because it just wasn't being used. There's a 4th chapter on so-called Foreign Office certificates. Now that is still of great interest because, as you probably know, this is the way that the British authorities from time to time inform the court, usually at the court's request, what their position is on matters relevant to international law. And the courts often regard those certificates as binding upon them and as conclusive. A relatively recent one was when there was difference of view as to who the government of Libya was. The banks needed to know, because there were a lot of Libyan students here. The banks had money from the government of Libya to pay the students so they could continue to be here and live here. And they didn't know on whose instructions to give money out. The Gaddafi government, regime, or the transitional government. And the British government thought of just giving all the facts and letting the court decide, which would have meant he went all the way to the Supreme Court, and the poor students would be starving, or issue a certificate just saying, we regard the transitional government as the government of Libya. And that's what they did, and the court said, thank you very much, that's extremely helpful. We decide that the government of Libya is the transitional government. I think these Foreign Office certificates are so important and can be quite good. And then there's a final chapter on the reciprocal enforcement of judgments. So that's what he thought the contact points were between international lawyers and, international law and practitioners. And you can just see how different it is today. If you look at the international relations title of Halsbury's Laws of England, you'll see that it covers almost every aspect of international law, is thought to be relevant for the laws of England, has come up in cases, and there's been a big change. Now another Foreign Office legal advisor I would like to mention is Miss Joyce Gutteridge. The Foreign Office actually has a lot of women in the legal advisor's office, about 50%, but still not the top number yet. Indeed, when I was, just before I left, every department of the office was ordered to ensure that 35% of its staff were women. And I said that would be very difficult for me because I already had 50, but I'd try my best. They didn't. The human resources people didn't think that was funny. But anyway, there we are. Anyway, Joyce Gutteridge wrote a really good book on the United Nations. She wrote this in the late 60s, having spent 4 years at the UK mission in New York, and it's a very authoritative statement of what the position was in the 1960s, which is still basic to what it is today. And it can be relevant both to understand the history of the UN Charter, but also because you might need to know what the law was in the 1960s, as I did recently in the Chagos Archipelago case between Mauritius and the United Kingdom, where Mauritius was arguing that the right of self-determination was part of international law on the 8th of November 1965, which was the key date on which the Chagos Archipelago was detached from Mauritius, and that it prohibited what had been done. We said that it wasn't the law, that the law didn't develop until maybe the Friendly Relations Declaration, maybe when the covenants came into force in 1976. Had I thought about Joyce Gutteridge's book, I would have realised there's a whole chapter about self-determination in the 1960s, which has some extremely helpful information. I've read it now, it's a bit late. Anyway, we argued the matter and the court happily avoided having to decide it, so it didn't really matter. But that's another example of how a book like that can still be very relevant. Now, I've already mentioned Professor Bowett's book on the law of the sea. He said a very strange thing in that book, which I think was not very perceptive. He said that he decided not to deal with the law of sea in time of war. And his explanation was that it is an aspect of the law which may be of limited relevance for the future, and it is somewhat depressing for the lawyer. Well, it may be somewhat depressing, but that didn't stop Daniel O'Connell, a great naval man and a great international lawyer, writing what is possibly one of his best books in this series, The Influence of Law on Sea Power. That, I think, is a really substantial book. It's still relevant today. You only have to think of what's happened since 1975, 74, when he wrote it, to know just how relevant it is. All the kinds of legal issues about neutrality, about passage through straits, etc., that he deals with come up on a daily basis these days. You only have to look at the South China Sea to see the relevance of much of what he's doing. And he wasn't the only one to deal with the use of force, which is, in a way, appropriate, given that these lectures are in honour of Edward Melland Schill, who died at the age of 25, I think, on the battlefield, or at least was injured and then died later that day, exactly 100 years ago in 1916. So in the series we've got Quincy Wright, The Role of International Law in the Elimination of War. I think that's a rather optimistic title, but anyway. There's Leslie Green on the law of armed conflict, there's Nigel White on the United Nations and the maintenance of international peace and security, and the late Tony Rogers on, with a book, a very interesting book, entitled Law on the Battlefield. Now, one thing you might notice when you look at this series is that most, or many of the authors are both practitioners and academics. They combine the two, which is something that's quite traditional in international law. If you go back to Grotius, he advised the Dutch East India Company. If you go back to Gentili, the first titular professor at Oxford, he advised Queen Elizabeth I on what to do with the Spanish, pretty effectively, I think. Now, if you look at the series as a whole, and look not just at the substance, but at the style, I think you can see that a lot has changed in the last 50 years. In my view, in these early books, there's a lot of admirable qualities that are perhaps less commonly found today, but I'll be rather careful. I'll just mention three. The first is brevity. Most of these books are scarcely much longer than a very long article would be these days. I've already mentioned that book. I think that's admirable. The second is clarity. These books are well written, they're easy to read, there's no jargon, and they're even stylish in places. And I don't always find that in modern writings on international law. And lastly, there are hardly any footnotes. So I think, all in all, they get my applause. I'll now take far too much time. It started a bit late. I'll be brief, perhaps not too clear, but there certainly won't be any footnotes. And I'll talk about the role of writings in public international law very briefly. As you know, the International Court hardly ever refers to writers, certainly not by name, but that doesn't mean that the judges don't read and are not interested in what is there. Other international courts, such as the European Court of Human Rights and national courts, refer to writers more frequently. The English courts, in my view, refer to them too often, and often give undue weight to authors, whether highly qualified or not. As you know, the starting point is Article 38(1)(d) of the ICJ statute, which says that in determining the law, judicial decisions and the teachings of the most highly qualified publicists of the various nations are a subsidiary means for the determination of rules of law. A subsidiary means, that of course means that they don't make the law, they're not a source of the law, they are a way of discovering the law, an aid to finding the law, they're auxiliary, the French term is moyen auxiliaire. Jean wrote with unusual clarity, scholars are not law makers. And that's a good, clear statement, John. Congratulations. Really excellent. And I'd like to quote again from your book, because I think you've said about writers something that I couldn't possibly say. In your book on formalism, you say, although international legal scholars themselves may be tempted to see their offerings as more influential than they really are, and even though their contribution is more modest today than it used to be a century ago, the states have grown weary or perhaps wary of the influence that scholars can have, their writings, their opinions and their decisions also influence lawmaking and international legal adjudication. I like that quote. I like the thought that scholars may be tempted to see their offerings as more influential than they really are. And of course this point, the role of writings, has been so well expressed by American and British judges. There's the famous quote from the Paqueta Habana case, where they said, the works of jurists and commentators who by years of labour, research and experience have made themselves peculiarly well acquainted with the subjects of which they treat. You recognise yourself. Such works,
no, just makes me so low.
Such works are resorted to by judicial tribunals not for the speculations of their authors concerning what the law ought to be, but for trustworthy evidence of what the law really is. That's a famous quote, but I think it's so well expressed in the year 1900, I think that case is. And then, in the same case, the Chief Justice dissented, and he said of writers that their lucubrations may be persuasive, but not authoritative. You all know what a lucubration is. Well, I looked it up, and it means laborious work, study, thought, especially at night. Literally, it means, it comes from the Latin word lucubrare, which apparently means to work by lamplight. So the lucubrations of scholars are persuasive, but not authoritative. And then in the English courts, back in 1778, the judge said, in the Renard case, a pedantic man in his closet dictates the law of nations. And Hume, I don't know, I suppose closet meant his office.
Yeah.
A pedantic man in his closet dictates the law of nations, and who shall decide when doctors disagree? Bintus Hook, as is natural for every writer or speaker who comes after another, is delighted to contradict Grotius. I mean, they really understood writers and international law back in the 18th century or 19th century, I think. And they were right, these judges. You have to be very cautious when looking at writings. The value is very markedly different. Writers often are not trying to state the law as it is, but to advocate its development, but they don't make it clear what's lex lata, lex ferenda. Another risk is that writers, of course, sometimes reflect their national or personal perspectives, and above all, they differ greatly in quality. That's why the statute of the ICJ talks about the most highly qualified publicist. But of course, it's very difficult to discriminate. Now, I'll just say a very quick word about the International Law Commission, because this year, last year, we adopted a draft conclusion about writings. And after a lot of debate, where I proposed something rather modern, using a word like writers or writings, we went back to exactly what was decided 96 years ago for the statute of the Permanent Court of International Justice. We kept exactly the same words. We now have a conclusion that says teachings of the most highly qualified publicists of the various nations may serve as a subsidiary means for the determination of rules of customary international law. It's about customary international law. And then there'll be a long commentary, which I'm working on, not long, but a couple of pages of commentary, which I'm working on at present. Now, why did we use teachings instead of writings? Two reasons, really. Firstly, it was suggested that teachings sounded more authoritative. Anyone can scribble writings, but a teaching, la doctrine in French, just sounds more serious. So it's a good word. And another reason why it was a good word was that we realized that a lot of things nowadays are not in writing. They're lectures. They're in different forms. So teachings came back into favour. Then the phrase, the most highly qualified publicists. Well, the word publicists has always puzzled me. It's publiciste in French. Though it was actually put forward in the Root Philibert plan to common law members of the committee that drafted this statute. But publiciste in French is a lawyer who is qualified in public law. And so it's a sort of funny translation of public lawyers, because you have privatiste and publiciste. I thought it just meant journalists, but anyway, that's where it comes from. They won't necessarily be specialists in public international law. You can have good writings about international law, which are valuable by other lawyers, or even by non-lawyers, writings from diplomats and others. The reference to the most highly qualified publicists shows we decided to keep. People wanted to keep it, which indicates that Melland Schill authors certainly are all highly qualified publicists. I remember appearing in court in England, and the judge said, "What value should we attach to these all these articles you put in?" It was an issue where there was no case law, so we put in lots of articles. So I thought about that, and I said, well, you can ignore the PhD, the article written by a PhD student. Actually, it's because I disagreed with it. I didn't want to pay attention to it. I won't say who it was. He's now a professor. We should probably guess.
Oh dear.
Not in this room. So in the end, we kept the exact wording, very much the wording of the the statute from 94 years ago, 96 years ago. I was going to say a word about the role of the work of the International Law Commission, because I proposed that this just be regarded as teachings of publicists. And a lot of the members of the Commission said, oh, no, you can't put us in with those writers. We're much more important. Look, we get quoted by the International Court. Well, it's not going to look very good if we say that, is it? And anyway, it's not what we do, because I think the work of the International Law Commission is, its value is when it's had a favourable reaction from government. If it's been endorsed by the UN General Assembly, of course, if it's been converted into a convention. But as such, the work of the International Law Commission is not necessarily of value, any more value than that of a writer. Though I do use it in court quite often, and it's being used today in the Supreme Court, I think, by the other side in the case. They're quoting one of my reports on customary international law to try and establish that the resolution of the Red Cross is not reflecting customary international law. Anyway, I think I'll stop there. Just congratulations again to the library, to the press, to the publisher, to the law school, and to Milk. I wish you had a better, come up with one like World International Norm Engineering. Why?
Why sounds good?
Milk sounds a little. It's too late to change it now.